Okay, well, we've got a few preliminaries, so let's go ahead and begin. Welcome to all of you. One of the pleasures and consolations of this year has been to welcome folks from far and wide across our college community and beyond, students, staff, faculty, alumni from both campuses. So glad to see so many of you tuning in today. My name is Walter Sterling. For those of you who may not know, I'm a member of the faculty and the dean of St. John's College in Santa Fe. This is our weekly contribution to the Dean's Lecture and Concert Series. For those of you who are trying to keep an eye on what's coming up, we have two talks next week, both Wednesday and Friday, 4:30 p.m. Mountain Time. We have Howard Fisher lecturing on Wednesday, and on, I believe, Magnificent Pendulums, I think is the title, and then Bree Wooten lecturing next Friday on Aristotle's De Anima. I do not have the title in front of me. So information on those is on our website, also in the weekly calendar, the ephemera, and a flyer will be sent out to the campus community next week. Today, we have my colleague and friend, Martha Franks, who I want to start actually by thanking for participating in various events, the way it's shaken out this fall. She was a panelist last week and then a few weeks ago on another kind of forum we had on a Supreme Court opinion. So I thank you for leaning in, like a lot of us have to this year, to trying things out in new ways. And we're so happy to have you lecturing today. So Martha is an alum of St. John's College and a longtime visiting tutor in Santa Fe. Her career before and during that time has been as a practicing attorney. It is our habit not to introduce our own were we in the Great Hall on campus. Martha would just be walking up to the podium, but in this forum, I like to at least say a couple of things. But I'm not going to say much more than that. Except that her background really gives her a unique voice and role in our community, and we welcome it and we learn from it. The one other accomplishment I would like to mention is her experience together with her husband, tutor Grant Franks, teaching in China over several years that led to a book, which I commend to all of you, titled Books Without Borders. Homer, Aeschylus, Galileo, Melville, and Madison go to China. So really a wide range of interesting experiences that Ms. Franks brings to us. And today, the title of her talk is The True Embodiment of Everything That's Excellent, Law and Philosophy. Ms. Franks will be speaking for about an hour. We'll take a very brief break at that point, just a couple minutes. Then we'll have a question period that we invite you all to stay for and engage with. And with that, Martha, I'm going to sort of hand things over to you.
Thank you, Walter. Good evening, everyone. My name is Martha Franks, and I am a Johnnie. I admit that I am powerless over my interest in philosophy. I'm also a practicing lawyer, having spent a career specializing in the arcane world of water law, a kind of law that raises strong passions in the desert southwest of Santa Fe. I wanted to give this lecture because St. John's students considering law school have sometimes asked me about my experience. Those conversations have caused me to try to think and speak clearly on a question that these students often ask. That is, how I see the practice of law relating to my first intellectual love, the love of philosophy. I did not see much relationship at first beyond the number of books involved. Next slide, Walter. I decided to go to law school after graduating from St. John's College, mostly because I couldn't think of anything else practical to do. That's the first one. Could you go on? There we go. I assumed with some grief that I was leaving philosophy behind for something smaller, less elevated, and less interesting. At St. John's, I had enjoyed the luxury of learning for its own sake. But in law school, I told myself grimly, there would be none of that. Only the task of buckling down to dull reality in order to acquire the tools to make a living. This depressing assumption proved to be wrong. I found that law and philosophy have a fruitful conversation. Law, it seems to be now, serves as a kind of laboratory for philosophy, forcing ideas into practical situations that show where they are sound or unsound. In a book, an idea may stand in isolation, untested, and therefore unclear. But when an idea erupts into the world, as when it is cast into a law that demands obedience, it both acts and is acted upon. Abstract principles are acted upon by the unpredictability of human conflicts, giving rise to new analyses that are then challenged again by some new turn of the world. What comes about as a result of ideas working themselves out can be surprisingly and sometimes happily different from what their originators expected. Not only does the world change ideas, but of course, ideas change the world. In this way, law can act like an art, shaping the medium of society as an artist's conception shapes marble or paint. Human beings are particularly slippery medium, in my experience, and the art of law does not contain our infinite variety. As with all arts, though, the continued effort to impose ideas on unruly material can lead to extraordinary expressive achievement. I've come to believe that the law, far from being small, is a magnificent accomplishment because of this conversation between principle and practice. W.S. Gilbert, the lawyer turned lyric writer of the team of Gilbert and Sullivan, calls it the true embodiment of everything that's excellent. That's slide 3, Walter. And so it is. From the moment I entered law school, my Johnnie habits led me to look for an accounting of what law means and where it comes from. I suppose I was imagining someone asking Socrates whether law can be taught, and Socrates insisting that he could not answer that question until he knew what sort of thing law was. Almost immediately, I bumped into the same kinds of questions that we study here at the college. The biggest was the legal version of whether there exists a source of truth separate from opinion. We meet this question in our first year at St. John's, reading the Meno. That's slide 4, Walter. With its argument that knowledge is not created, but remembered, and that we will be better, braver, and less helpless people if we try to tether our opinions to knowledge. Many of us fall in love with at least one of the experiences on which that argument is based, the sense of clean, elegant, satisfying conviction of truth that Euclidean geometry gives. When the slave boy in the Meno follows the geometrical argument and agrees that his first notions of how to double the square were wrong, it seems that there must be something more than mere opinion in the world, some actual truth that he and we can recognize if we are clear and logical enough. Even if you think that Socrates has led him there, it is the slave boy himself who has the moment of personal realization of the truth of the geometrical relationships. I remembered the Meno one day when listening to an argument between two friends of mine, a lawyer and an engineer, regarding technical aspects of water deliveries under a certain legal document. After a long exchange, the engineer finally said, exasperated, "I can explain it to you, but I can't understand it for you." In the Meno, the question about truth turns on whether learning means uncovering understanding already buried within us, waiting to be revealed, or whether learning consists rather of having facts imposed on us, hard, alien bits of knowledge that demand our assent on the say-so of Egyptian priests or other external authorities. The corresponding distinction in the legal world is whether law is something written in the universe, natural, unchangeable, and discoverable, or whether law is a set of opinions that some humans oppose on other humans by the exercise of authority. Read force. The first of these positions is called natural law theory, and its proponents, notably St. Thomas Aquinas, that's slide 5, argue that societies must seek to make legislation and judicial actions match, as much as possible, the timeless structures of truth. Natural law theories often assert that the law has a divine origin, as in Moses' receipt of the law from God's hand, or the Roman king Numa's consultations with the goddess Egeria. We all have experiences that seem to support a natural law standard along the same lines as what Socrates demonstrated in the Meno. We have deep-seated feelings about justice. These are not, or do not seem to us to be, arbitrary choices that we make or personal whims. They appear to us to be as immovably true as any fact. It is wrong to kill. It is wrong to steal. Even a 2-year-old, given a smaller piece of cake than her brother, knows somehow how to shout, "That's not fair," with a strength of conviction that matches the certainties of Euclid. A sense of justice seems grounded deeply within us, recognized as readily as the truths of geometry. If that's the case, the business of legislators should be to enact laws that reflect justice, and the business of a lawyer is to persuade courts and juries to recognize and follow the sense of justice within. This is an accounting for what law means and where it comes from, that is very attractive to those of us who are bitten by the philosophical bug. It is wonderful to contemplate beautiful, divine, logical structures governing human society. On the other hand, in the law, there's always another hand. On a day-to-day basis, the grand shining standard of justice with a capital J can seem far away, not just because we are mired in cynicism and surrounded by unscrupulous characters, but because large principles often just don't speak to the particularities that we confront. Thus, despite the attractiveness of natural law theory, it is perfectly clear that some laws are just agreements, contracts that don't invoke intrinsic justice. There's no platonically based ideal rule about which side of the road to drive on, for example. Slide 6, Walter. People have just chosen something arbitrary, and that arbitrary choice is then enforced. You can go to jail for ignoring traffic laws just as much as for stealing. No one will let you off the hook because traffic laws do not reflect divine justice. This second kind of law is important to a functioning society. If there were no rule at all about which side of the road to drive on, there would be unending clashes among travelers. Oedipus experienced this. As a lawyer, I've often reflected that the whole Oedipus cycle could have been avoided if there had been traffic laws in ancient Greece to prevent the conflict between Oedipus and his father. We need this kind of law, these social agreements on arbitrary rules, and they can be reached without having to undertake the daunting task of determining what justice is. Looking to this second type of law, some legal philosophers argue that all law can be understood in that way, as a matter of agreements. There's no need to ground the law in divine justice, these thinkers claim. Even laws against murder and theft, or unequal cake slices, can be seen as the consequence of a bargain. I agree to accept such laws because I want myself to be protected from murder, theft, and too little cake. I am willing to give up my own impulses toward crime and greed in exchange for that protection. For matters like which side of the road to drive on, which simply needs an arbitrary decision, appealing to justice can seem a little silly. Once I argued what's called a procedural motion to a judge, which means that the issue we were arguing about was not much concerned with justice, but only with the order in which a lawsuit would proceed. I offered my argument, opposing counsel offered his argument, and when we were done, the judge turned his chair around so that he was facing the back wall of the courtroom. As we watched the back of his chair, we saw a coin rise in the air and fall again. I think the judge was joking, expressing irritation that we had made him listen to arguments on an issue that we really should have been able to agree on. But I'm not sure. The contract approach to law is, at the level of foundational government, an application to the field of law of social contract theory, a theory of government offered by Hobbes, Locke, and Rousseau, philosophers we read in the junior year at St. John's. That's slide 7, Walter. Under this theory, the foundation of society is an implied contract, according to which each of us gives up some freedom in exchange for social benefits. Each of us, by being born into a society, are assumed to have implicitly agreed to the laws that exist there, just as we drive on the left side of the road when we find ourselves in Australia. If we see law in that way, then legislators don't spend their time seeking justice, but instead they make and apply law according to the agreements that have been achieved among the particular powers that exist in a society. Under a theory that law is a matter of agreements, a lawyer arguing a case looks only to the actual language of the agreement, not to a separate standard of justice, and tries to persuade the judge that his or her side of the case more perfectly upholds the meaning of that agreement as fully expressed within, as lawyers say, the four corners of the document. It's easiest to see how this works in the field of business law and contracts, a topic that's very big in a modern American law school. Slide 8, Walter. The professor who teaches the subject of contracts is understood to be the center of a first-year student's experience. The subject of contracts explores how agreements can bind individuals in ways that do not require any independent standard for justice. If two people have entered into a contract and one claims that the other has breached the contract, the lawsuit that follows will be concerned with what the contract says and means, not with capital J justice. Thus, if someone entered into a contract to pay $1 a widget to a widget supplier, it does not matter if the actual market price for widgets is 75 cents. Society has a policy interest in enforcing contracts, even if they're not entirely fair, so that commerce can be reliable. Another way to look at it is that justice as between these two people is defined as their agreement expressed in the contract, and no other standard of justice is required or relevant. Either way, the contract requires the dollar. It looks like a pure philosophical or perhaps theological issue. Which of these two possible foundations for law is right? But the issue was not fought out in the world on the basis of pure philosophy. Natural law theory, when tested in the laboratory of actual human situations, shows some practical shortcomings. Suppose you want to know the natural law for the authority of kings. There was no more important question in the West at the time of Thomas Hobbes and for many years afterwards. Lots of people offered answers saying, for example, that God had given kings a divine right to rule and to be obeyed without check. Others argued that the natural law of the authority of kings arose from below and God was on the side of the people. Neither position, however, commanded enough agreement at the time of the English Civil War to shore up a peaceful society. Whichever one was the truth, society was falling apart. You might say, disapprovingly, that people ought to agree on the truth or what God wants. But the practical reality is that they don't. And when both sides of a disagreement believe in the ideal of truth, but still disagree, the conflicts can be particularly terrible. If truth is at stake, there is no possibility of compromise. Those conflicts are to the death, even to a king's beheading. Slide 4. In this state of affairs, people began to wonder whether, with regard to government, as opposed to geometry, agreement might be as important as truth. Maybe we can bypass the terrible conflicts around truth if we instead make agreement our ideal. If an agreement is held up as the ultimate standard of law, then perhaps the temperature of the argument can go down and conflicts can be more easily resolved. It's a valuable thing, this bringing down of the temperature, transforming what might have been violent struggles into courtroom arguments, and even into exchanges in which it is established that what could be hostile feelings will be expressed as jokes and become the possibility of friendship. I was on the way into the courthouse one day when I found a marble on the steps. Picking it up, I walked over to opposing counsel, also on his way into court. "Here," I said, offering him the marble. "I think you lost this." He didn't skip a beat. He took the marble and replied, "Thanks, it was my last one." The two approaches to law, natural law theory and law based on a theory of contract or agreement, are both still with us. They may look like they cannot coexist, but they do, in fact, in the practical, rough and ready world of the law as practiced. A natural law theorist, Stephen Thomas Aquinas, will concede, for example, that while some law is based on intrinsic justice, it's fine to have arbitrary agreed upon rules about traffic laws or contracts. A contract law theorist might try to be more radical in claiming that there's no such thing as intrinsic justice. But contract law theory has some limitations in the practical world too. And in legal practice, natural law theories continue to crop up. Although a contract should, under agreement-oriented theory, be the final word on what will be enforced between two entities who have signed it, there's a natural law sounding check on that rule. If the contract is too unfair, a judge will overturn it on the grounds that, and this is a formal legal standard embodied in both statutes and law cases, it, quote, shocks the conscience of the court, end quote. A court's internal sense of justice, a standard that we first meet as children wanting our fair share of cake, can cancel a contract. The United States Constitution reflects the differing theories about the foundation of law. Slide 10, please. On its face, the Constitution looks like a contract with no pretensions to be anything but an agreement. In the preamble to the Constitution, for example, there's no language about truth or God or natural law. Instead, there is a statement of purposes, as is common in a contract. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. The rest of the version of the Constitution that was ratified in 1788 assigns roles and powers in a way that looks like what later legislatures did to create traffic laws. The Congress does some things, the president does others, and the courts yet others. There's no claim of intrinsic justice in the constitutional pattern of three branches of government with duties divided as they are. These were matters of agreement, apparently arbitrary agreement, based at most on prudential concerns. For example, members of the House of Representatives serve 2-year terms so that the whole House is subject to election every 2 years. Members of the Senate, by contrast, serve staggered 6-year terms so that only a third of the Senate is up for re-election every 2 years. The framers may have chosen for there to be this difference between the two houses of Congress because they thought it prudent for the Senate to have more continuity than the House of Representatives. The precise numbers, however, were simply chosen. There's no reason they could not have been different. There are plenty of other such things. The president must be at least 36 years old, for example, and infamously, some persons, enslaved Black persons, only counted as 3/5 of a person in determining how many representatives a state would have in Congress. Now there's a shameful departure from justice. Some historians argue that the 3/5 provision was prudent in that there was no other way to get agreement to the Constitution. Even if that were true, it only demonstrates that prudence is a very different kind of consideration than justice. As an aside, although there are likely people in this audience who are more qualified than I to talk about the historical effects of social contract theory, I do want to mention that the documentation around the drafting of the Constitution reflects that the framers were intimately familiar with philosophies associated with that theory, such as Hobbes and Locke. The US Constitution was the first complete written national constitution, perhaps intended as an explicit social contract. Although some might argue that the theory of the social contract extends beyond the structures of government into cultural matters, so that the Constitution is not an entire social contract. Still, it was a good deal more explicit than had ever been done before. Most nations arise untidily out of deep time and custom, with their social contract implied discreetly far in the background. It was unusual, perhaps shocking, at the time unique, to say articulately, exactly, and comprehensively what the agreement was that held together the government of the new nation. Thus, the version of the Constitution that was originally ratified in 1788 leans heavily toward a contract theory of the foundation of law. Yet the language of natural law theory was quickly added to the Constitution and was certainly part of the events that led to the creation of the United States. The Bill of Rights, the title of the first 10 amendments to the Constitution, was ratified by the states on December 15th, 1791, just 3 years after the ratification of the original Constitution. Slide 11, please. These first 10 amendments to the Constitution, as well as some of the later ones, notably the 13th and 14th Amendments, which were added shortly after the Civil War, take an approach to law that looks much more like natural law theory. They employ phrases like due process and equal protection, which are undefined, leaving the courts to consult some internal sense for what they mean. In Brown against Board of Education, for example, where the United States overturned segregated public schools, it rejected its own precedent simply by saying that no one can any longer believe that separate education does no harm. In Loving against Virginia, striking down a law against interracial marriage, the Supreme Court says that there is, quote, patently no legitimate overriding purpose, end quote, for such a law. When lawyers and judges use words like patently, obviously, clearly in a legal document, instead of quoting precedent or making an argument, it likely means they are appealing to a sense of justice that invokes natural law theory. Really, the very notion of rights, as in the Bill of Rights, suggests something with a stronger connection to truth than mere agreement can have. The whole point of asserting that people have rights appears to be to say that no government has the power to make a law that infringes upon those rights. Now, a strong-minded and stubborn proponent of a contract theory for the foundation of the United States might argue that the recognition of rights in the Bill of Rights and other amendments to the Constitution is still contractual. That is, that these are not natural law rights, but rights that the nation has agreed to in its founding document, and from which it could theoretically withdraw agreement. But the claim that the government does not have the power to infringe upon certain natural rights was essential to the United States' understanding of itself, even before the Constitution. It is the claim on which the fledgling country justified its Revolutionary War against England. The Declaration of Independence, slide 12, please. Signed in 1776 by many of the same people who framed the Constitution, memorably used the natural law language that is missing from the preamble of the 1788 Constitution. I'm sorry about the gendering of the language. When in the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and of nature's God entitle them. A decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. We hold these truths to be self-evident. That is, they are patently or obviously or clearly true. That all men are created equal, that they are endowed by their creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. Thus, both before and after the 1788 social contract-looking Constitution, the new United States of America embraced an idea of rights that inescapably invokes the language of natural law theory. The competing theories for the foundation of law, incompatible as they seem to be, both form essential parts of American law. Is this an embarrassing incoherence that demonstrates that I was right in my original notion that the law is smaller than philosophy? As I said at the beginning, I've come to believe otherwise. The presence in our founding document of both theories and the foundations of law, about the foundations of law, forces them into a conversation. It's a conversation between the ideal of self-evident truth and the messiness of political clashes shot through with personalities and self-interest that can only be composed by agreement. Good and interesting things come out of this conversation. These observations about law have been general, but everyone's experience of the law focuses on particular subjects and events. My own experience in the making, passing, following, and interpreting of a particular law happens to involve water law in New Mexico. I want now to show how the conversation described above worked in a particular situation with which I am familiar. In arid New Mexico, there are few subjects of more legal angst than the law of water. And because water flows, it doesn't fit easily within the common law system of ownership that was developed in water-rich England. So a special doctrine of water has grown up in the American Southwest called prior appropriation law. Under this doctrine, the people who began using water first have the best right, have senior priorities, and are first in line for the available supply of water. If there's not enough water to supply everyone, and there is never enough water to supply everyone, the people who began using water later and have junior priorities get nothing. In order to work, this legal rule needs someone to divide up and distribute the water in accordance with those priorities. Before that can be done, someone must make decisions about who has what priority date and how much water they have the right to use. New Mexico statutes give those decisions to the courts. But court cases that try to sort out decades and centuries of water right claims take a very long time. They make jaundice against jaundice look like a fast food order. In the 1990s, I was lead counsel for the state of New Mexico in one case that was first filed the year I was born. I have moved on, but the case is still going strong. I expect it to outlive me. Some of us water lawyers had the idea that there should be a law that allowed the water agency for the state, the Office of the State Engineer, to make provisional decisions and administer water in priority, even if the court had not completed its work. I helped to draft a proposed law to do this. As we drafted the law, my colleagues and I spent a lot of time trying to make sure that we had thought of all the ways that the language we proposed could be read, hoping to head off misunderstandings and quarrels. My habits of critical thinking cultivated at St. John's came in handy here. In the end, we did not just give the state engineer the power to administer water, but required the state engineer's office to first promulgate regulations to say exactly how it would be done. We thought of ourselves as acting on principle and trying to effect an ideal, making a change in the law that was necessary to make it meaningful, while also ensuring that the power we were giving to the state engineer would be transparently exercised. Once we had a draft, the next step was to bring the draft to a legislator. We found one who thought this was a good idea and was willing to sponsor it. And then we began to lobby other legislators to see if there were or might be generated enough votes to pass the proposed law. When I acted as a lobbyist for my bill, I prepared extensively for reasoned debate on the merits of the proposed law. It happened once or twice, but I was mostly disappointed. Legislators' reactions were not usually based on the substance of the law, but on their own political allegiances or their hopes of using the proposed law as a bargaining chip towards something else entirely. Slide 13. I'm not unsympathetic to this, really. There's no time to understand things fully in the practical world. Socrates would have slowed down government to the point of impossibility, I'm sure. The political stars aligned for us, and the bill progressed in the legislature. At every stage of being considered in various committees, then being voted on by both houses of the legislature, and then going to the governor for signature, There were political calculations, sometimes suggested changes, and much happenstance. My law made it through these steps chiefly, I think, because the lobbyist who most opposed it did not get notice of a key vote in committee. He was furious, but it's hard to get a do-over in that pressured world. When a bill survives all that, becomes law, and enters the statute books, everybody then finds out how it will actually work in the world. In the case of the law I was working on, the Office of the State Engineer obeyed it by promulgating new regulations. Making regulations is just like making laws, only with a more detailed focus. Finally, the statutory and regulatory language was in place. The attempt to distill ideas into specific, well-described powers was complete. Sometimes a law is given a little time to be applied in practical situations. In this case, no. Instead, there was an immediate challenge to the constitutionality of both the law and the regulations in court. A determination of whether a law is consistent with the Constitution is what the courts do. They look at a law, make a judgment about what the legislature intended to do with it, and then develop an opinion on whether the law is consistent with either the state or the federal constitution, depending on which court. State constitutions cannot be in conflict with the US Constitution, however, so usually they repeat it while adding things. So it's a single decision. This is why the makeup of courts causes such passion in the political world. The court has the power to, in effect, cancel laws passed by the legislature if the court finds that the law conflicts with the Constitution. The process reflects the extraordinary centrality of the Constitution in American law and the importance of how people read it. The Constitution is not merely an historical document, but an active set of standards constantly consulted by courts. I've often thought about the ways in which this is a special kind of reading, different from how we read Plato or Shakespeare or Kant. Judges don't read the Constitution to assess whether its statements are true. They read the Constitution to use it to evaluate other laws. The only real comparison is the way some people approach the Bible as the standard of truth against which other books and beliefs are measured. Judicial analyses and interpretations of statutes are the mechanism by which ideas and practicality explicitly learn from each other, like writing up the data in a scientific experiment. When a court does an analysis and interpretation of a statute, the court publishes an opinion explaining its thinking and its conclusion. Those explanations are what fills all those law books. Slide 14. The books are not filled with laws. They are filled with judges explaining their analysis of what happened when the abstract language of a statute collided with the untidy particularities of the human beings it was attempting to control. I'm happy to report that after a decade of litigation, innumerable briefs, and several oral arguments, the law I helped to write was upheld as constitutional by the United States Supreme Court. It was a wild ride. Had my law not been upheld, and whenever a law is held to be unconstitutional, the legislature could, of course, return to the same hoped-for ideal and try again to write a law, this time taking the judge's analysis into account. The wild ride begins again. It is, as I say, a conversation, ideals to particulars to ideals again. I think my favorite instance of this story of how laws are made, meet the world, and are then assessed involved a statute that I was looking at as part of my work with Native American water claims. The statute was passed in the 19th century when Congress had a paternalistic attitude towards Native Americans and was concerned that real estate moguls from the East were coming out West and conning Native Americans out of their reservation land, taking advantage of a cultural difference in what it meant to own property. Native Americans were getting ripped off so that real estate moguls could get rich. Congress addressed this by passing a law stating that in every transaction involving real property, land or water, quote, in which an Indian may be party on one side and a white person on the other, end quote, the burden of proof in court is on the white person to show that the transaction was valid. This law is still on the books. The real estate moguls of the 19th century thought about that for about 15 minutes and then hired a bunch of black guys to go out west and enter into real estate contracts with Native Americans. This is the kind of thing that happens in the rough world of law. People finding ways around rules in pursuit of their self-interest. Law, unlike philosophy, is always dealing with people who make no pretense of being impartial and will look for advantage any way they can. Anyway, somebody then sued to get the benefit of a changed burden of proof in order to set aside a contract between a black person and a Native American. The argument was that, despite the seemingly perfectly clear language of the law, Congress could not have intended to leave such a loophole, and the phrase white person should be understood to mean black persons too. The case wound its way through the appellate levels of courts and finally arrived at the United States Supreme Court. The Supreme Court, as it happened, found a way to avoid making a decision on the substance of the case by going off on a procedural question, which they love to do when they can. That meant that the substantive decision of the court just below the Supreme Court was effectively upheld. The reason I like the case so much is that the end result of it did justice, and did justice while providing an occasion for the United States Supreme Court to find that, at least for purposes of this law, black is white. Next slide, please. This story illustrates how, because law is always dealing with people who make no pretense of being impartial, every effort to bring the laws of a society closer to some good purpose, some hoped for justice, must bear cannily in mind all the possible ways in which that good purpose could be twisted to serve somebody's self-interest. It is an exercise in trying to get ideas and ideals expressed in highly recalcitrant material, like an artist trying to sculpt soap bubbles in granite. We keep chipping and we learn in both directions about the durability of ideas and the malleability of stone. That is the vertical story of how law is made, in which ideals descend to particulars and go back up again. Most of us meet the law horizontally, so to speak, encountering a conflict and discovering only then that the law as it already exists may differ from or match our ideals. I saw this type of encounter with law play out in an Endangered Species Act case involving a great many people holding many different ideals. The Endangered Species Act was passed in 1973, mostly because the bald eagle was threatened with extinction, an embarrassing fact that seemed to many a sign of the decline of America. Slide 16. Congress, filled with idealism and patriotic good purpose, passed the ESA, forbidding people to kill, harass, or harm animal or plant species that were in danger of going extinct. As this law encountered the world, there were a great many surprises. I don't think that anyone in Congress understood when the law was proposed just how many animal and plant species were on the road to extinction as a result of the industrialization of the earth, how ubiquitous they were, or how affected by a huge number of human activities. Nor was it very real to Congress, I suspect, that a law written with symbolic and attractive animals in mind would apply by its terms to little, ugly, seemingly pointless creatures. The draconian power of the law was also obscure for some time. It is still astonishing in this largely cynical world that the United States Supreme Court in 1978 found under the Endangered Species Act that the Tellico Dam project, on which Congress had already spent an enormous amount of money, had to be halted because of a tiny little fish called the snail darter, which happened to live just there and only there. Ideals spectacularly won out over money in that case. In New Mexico, the Rio Grande silvery minnow, next slide please, was listed as an endangered species in 1994. This fish has been greatly diminished by decades of human activity on the river, including the introduction to the stream of various non-native predatory species, the encroachment of human settlement into what were once broad, meandering stretches of river, and deliberate human efforts on the part of the federal government, no less, to get rid of what used to be known as, quote, trash fish, end quote. 7 of the 11 fish species native to the Rio Grande are already extinct. The silvery minnow is very close to the edge. With so much already lost forever, the environmental community in New Mexico felt a strong sense of urgency about changing water operations on the river and making sure that the river never goes dry. That means you can release water from dams timed in such a way that the river never goes dry. The river has gone dry historically, both as a result of drought or human diversion. The environmental community argued that human diversions must stop so that water is left in the stream to ensure the fish's survival. This argument hit the water world in New Mexico where it lives. Water in arid New Mexico is so very scarce, suggesting an entirely new type of need, that water should be taken from existing uses and devoted to this small minnow, ran smack into entrenched and complicated human water interests along the river, farmers, cities, industries, ranchers. A century's worth of interstate agreements with Texas, contracts and water use permits would have to reassess their supply of water if the ESA were applied in the draconian way it had been applied in the Tellico Dam case. I have sat at large conference tables in the company of people representing these seemingly incompatible interests, listening to them express such stark disagreement that anger often flared. I was afraid to look for lost marbles. In my experience, everyone at that table felt that they were operating out of idealism. The environmental community felt the Earth's crisis. Farmers saw their historic way of life threatened and bridled at the notion that the crisis of the Earth placed a disproportionate burden on their traditional livelihood. Cities were trying responsibly to provide drinking water for their citizens. The state was trying honorably to meet its obligations to Texas under an interstate agreement known as the Rio Grande Compact. Other actors had other ideals they sought to protect. I even heard one person express the religious belief that the Endangered Species Act is contrary to biblical teaching, which says in Genesis that human beings have, quote, dominion, end quote, over all the creatures of the earth. Layers upon layers of long established legal arrangements, traditions, customs, beliefs, and history shaped everyone at the table's feeling of what justice meant here. At the same time, all the people at that table, without exception, mixed some blindness and self-interest with their ideals, a mixture that I've tried to show characterizes every step of the process of making and applying law. Everyone had motives in addition to their ideals, and no one was prepared to spend the time or commitment needed to sympathize with the positions of others. For one thing, that's not what they were getting paid for. So, interspersed with the passionate exchange of sincere ideals, the discussions included a lot of horse trading that embraced some creative suggestions for agreements that would address the situation of the fish while minimizing the losses to human interests. It was a mixture, I thought, that mapped onto the two types of legal theory present in the United States Constitution. Arguments from ideals or appeals to natural law theory. Horse trading looks like an appeal to the possibilities of contract theory. Both ways of approaching the controversy were essential to reaching, finally, the shaky, fragile arrangement that ultimately came out of those meetings, an arrangement that has kept the minnow alive so far, although it may fall apart at any moment. These meetings caused me to return to a famous legal author whose work I had read in law school. Oliver Wendell Holmes Jr. was a justice on the United States Supreme Court in the late 19th and early 20th centuries. He was known for his powerful defenses of freedom of speech. Those defenses of freedom of speech usually occurred in a dissent from a more cautious majority opinion by other justices on the court. Justice Holmes had an amazing ability to see where the law was going, though, and his dissents often became the majority opinion later, and thus the law. In his dissent, in Abrams against the United States, he remarked, looking at the Bill of Rights, that the United States Constitution was, quote, an experiment, as all life is an experiment, end quote. Before he became Justice Holmes, he wrote a book called The Common Law, which set forth in more detail his vision of the experimental nature of law. The book begins with a passage that felt to me like a description of what I saw at the conference table in the Silvery Minnow negotiation. Again, sorry for the gendered language. The life of, oh, sorry, I should have asked for slide 18. The life of the law has not been logic. It has been experience. The felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, avowed or unconscious, even the prejudices which judges share with their fellow men, have had a good deal more to do than the syllogism in determining the rules by which men should be governed. The law embodies the story of a nation's development through many centuries, and it cannot be dealt with as if it contained only the axioms and corollaries of a book of mathematics. In order to know what it is, we must know what it has been and what it tends to become. We must alternately discuss history and existing theories of legislation, but the most difficult labor will be to understand the combination of the two into new products at every stage. That's the end of the quote. I'm especially moved by that final line about the combining of history and theory into new products. The conversation between theory, ideals, and logic on the one hand, and the muddled chaos of history and self-interest on the other hand, is the cradle of new things in the world. I want to conclude this lecture by talking about the Greek playwright Aeschylus's Oresteia, a book which, as I reflect on it after some decades practicing law, seems to me to agree with Justice Holmes. Slide 19. The Oresteia, just to remind people, is a trilogy of plays about King Agamemnon's son Orestes, who killed his mother Clytemnestra. In the final play of the trilogy, the goddess Athena invents the institution of trial by jury and conducts a jury trial to determine whether, as the powerful but hideous Furies argue, Orestes should be punished for killing his mother, or whether, as the god Apollo argues, the killing was excused because it properly revenged Clytemnestra's ambush and murder of her husband Agamemnon. The trilogy was admired and performed in ancient Greece as a celebration of the importance of the structures of law in Athens, a city famous for its litigation. When I read the play as an undergraduate, I didn't think I liked it much. Instead of clear heroics, as in Homer, it displayed actions that were ambiguous and motives that were murky. It was a relief to move on to Plato and talk of sunlight and justice with a capital J. All the same, the plays stayed with me and even found their way into my senior essay. When I reread the play now, my respect for Aeschylus is boundless. For one thing, his skill at perfectly balancing the problem of being just to Orestes is astonishing. I once taught this play to high school students, and we redid the trial in class, adding arguments and witnesses, and asking a classroom jury to make a new decision based on our new trial and new evidence. In all three sections of the class, the jury, voting anonymously, was perfectly split on Orestes' guilt, just as they are in the play. Astonishing. More importantly, for the topics of this lecture, I now see Aeschylus as having offered a subtle and truthful view of how worldly circumstances interact with justice, a more useful view, as Justice Holmes said, than one that approaches the matter through logic alone. In the trial, as given in the final play, we hear the arguments of the Furies and of Apollo invoking justice, but we do not hear the deliberations of the jury. That is, we hear the lawyers presenting the two sides of the issue of Orestes' guilt, but we do not hear anyone trying to analyze the evidence and reason about it disinterestedly, treating it as an abstract philosophical or logical problem. All we get is the fact that the jury's votes are evenly split. Modern jury deliberations are also done offstage, obskene, as the Greeks say. The sense of justice is likely present in these hidden negotiations and the effort to be dispassionate, but it is not made the explicit touchstone for the result. This is distressingly clear when Athena breaks the tie and decides the case in favor of Orestes. She offers not the slightest pretense that it is capital J justice that got her there. She might as well have turned her chair around and sent a coin up into the air. The whole sequence reminds me of the silvery minnow discussions and, in general, of the mixture of ideals and practical agreement that makes law work. Claims of justice are made passionately in argument, and those claims are important in shaping people's views. But when arguments based on justice don't solve the problem when the votes are split, a choice must be made, even if it looks arbitrary. Following that, as Aeschylus shows us in the play, there is a long, hard slog of persuasion, where the party that lost the case, here the Furies, must be persuaded into an agreement that accepts the result. In the Oresteia, this involves a great many concessions of worldly power and gifts. The resulting arrangement looks shaky and fragile, laced through with continued threats of the Furies' power. But it is a new product in the world, a new balance for the city. I find it beautiful. Last slide, please. Thank you.
Welcome back again. Thank you, Martha, so much for an engaging and excellent talk. For folks who haven't done this, we'll take questions in two ways. You can either raise your hand. You should have a button for that that'll appear at the bottom of your browser. And we can take live voice questions, or you can type in a question to the Q&A function. You could also type in a question in chat, but we might be slower to see it there. So we've already got, actually, just let me ask, are you ready to begin? Are there any comments you'd like to make before we go ahead and take the first question?
No, I'm excited to hear what people want to know about.
Okay, great. We've got one question from a Mr. Grant Franks. Can you comment on originalism, a doctrine that has made some splash in the news lately? So you decided to leave the timeless for the timely very quickly there, maybe. So.
Originalism is the name for a particular way of reading the Constitution that I mentioned in my lecture, that Constitution, because of the special role it plays in American law, is read differently than any other book except maybe the Bible. And like the Bible, there is a whole industry of argument about what kind of reading is the right way to go about things. Originalism in particular is a reading, as I understand it, and this is not something in which I'm an expert, asks the reader, the judge who is construing the Constitution, to sort of put themselves in the minds of the original writers of the Constitution and try to think about what the original writers would have said about a particular question. And it becomes important when we're talking about things that just didn't exist in the world of the original writers of the Constitution. So, for example, there are some famous cases that found a right to privacy in for Americans, and under the rubric of that right to privacy, there's a guarantee of access to birth control. Those issues were just not in the air in 1788. And some people are scornful of the notion that there's somehow a right to privacy in the Constitution, arguing that it was imported there for the purpose of a kind of modern liberal tolerance of that was not in the minds of the framers. So that's my understanding of originalism, that it's one among several possible ways to read the Constitution. You could also read it as what's called a living document, where you don't look for the actual original intent. What you sort of think to yourself is, how does this language, how can it be made to work today in the modern conflicts that we have? And there are other ways to read the Constitution.
Thank you. Okay, I'll just remind people again, if you'd like to ask a question live voice, raise your hand and we can turn on the microphone. But we do have a couple more written questions. Simran Thapa writes, great lecture, thanks very much. Negotiation seems like a big part of being a lawyer. Is there something in the program that taught you about negotiation?
Well, thank you for that question. That's really interesting. I'll have to give it considerable thought. The Constitution itself, because it looks like an agreement, at least gave me a hint, even when I was an undergraduate at St. John's, that maybe you didn't have to fight out things along the lines of truth. Maybe you could agree. But I'm confident that I could think of more. Maybe I'll email you when I get more of an idea.
We can circle back to it if you have later thoughts. We have a question from Minjun Lee. Thank you for your wonderful lecture, Ms. Franks. My question is a law always just? Can a law be unjust? For example, in the Apology, Plato's Apology, both the demand of the prosecutor, the opinions of the juries, and the verdict of the judge do not appear just. Although in Crito, Socrates insists on obeying the law. If in our real life, we do not claim that any particular law is unjust, is the law always just? If a law itself is always just, you're getting a few questions here, does the verdict which seems unjust, such as Socrates' execution, come from the judge's wrong interpretation of the law? Just as you quoted, the life of the law has not been logic, but experience. There was a lot in there.
Yeah. That's a hugely important sort of complex of questions about, and I take it as an invitation to kind of apply the categories of natural law theory and a sort of contract theory to what happened to Socrates. If you are a natural law theorist, the heart of your claim is that there is no such thing as justice apart from the actual letter of the law. So the only thing that defines justice are the laws as written. I'm being a little cartoonish in my characterization of the contract theory. So if that's your view, then the feeling that we all have that Socrates was unjustly treated doesn't make any real sense. If he was properly tried and found in good order, procedurally correctly to be guilty, then that's justice. And it sort of seems like that's kind of the view he takes in the Crito, that he's not going to look behind the letter of the law. But I think that people reading those dialogues and trying on that analysis for size would view it as a refutation of the extreme form of contract theory, because the sense of injustice is so strong. Maybe the only general thing that can be said is, again, to point to how strong that sense of justice is, even though it turns out to be very difficult to turn it into agreement about what it means. And even though you can create this other kind of law which allows us to bypass it. I think that's maybe all you can say, at least in the short moment of a Q&A period. But thank you, Mr. Lee. That's a really interesting complex.
So we have a couple of questions coming in from other lawyer Johnnie combinations, though maybe in the opposite order of yours. So we have a written question from Ken Resnick, who is a GI alum and now a board member, but that was after a career as a lawyer, or at least beginning as a lawyer. Ken writes, while the confrontation of ideals and practical circumstances develop new products, isn't it the case that not all of these products are beneficial? For example, the series of fugitive slave acts that prolonged the suffering of slaves and still led to civil war.
Yes, I mean, of course that's so. And the only real answer to it from my point of view is, I mean, here's the situation as I see it. You have these negotiations like my conference table around which we're sitting a lot. We thought all of the interests that cared about the Rio Grande Silvery Minnow issues. Maybe we didn't have them all. The ideal is that when you have them all and a possibility of conversation, then you're going to be able to negotiate. When you don't have them all, when, for example, the people most affected by the Fugitive Slave Acts are politically prevented from being part of the conversation, then what you will be left with is not a solution to a problem, but at best, a tamping down of the angers and resentments that will ultimately destabilize. So that's my idealistic way of trying to suggest that if you do negotiations right, the new product will be helpful. But if you exclude critical members of the possible community, especially the members that will be most hurt by the result you reach, then all you'll do is get war.
I have a question from someone you must know each other, John Draper, who is another lawyer engaged in water law. I believe he's argued before the US Supreme Court and has a relationship with St. John's. He was a commencement speaker before. You wouldn't know all this from his questions. So from John Draper, can you say more about the Furies in the Aeschylus play and what they might represent in present society?
Thank you, John. Yes, John and I have worked together on Rio Grande Compact cases, as well as others. That's very interesting. I guess my first thought would be, some of my reactions to that are rooted in the play, which maybe, some of us are kind of on the fly here talking about Aeschylus. But I think I could sketch in some of it, that the Furies in the play represent the kind of old gods of passion and revenge, and are particularly connected to a sort of matriarchal protectiveness. And Athena and Apollo represent the new gods who are doing new things, creating these new products under the father Zeus. The one way to read the play is that the furies are when passion ruled the world. There is they certainly have their claim of justice, which is rooted in revenge. But passion is one way to characterize who they are. So maybe you would connect them up with the sort of self-interested side of things, when people are sitting at the table thinking, well, God is on my side, but well, also if we did it this way, I could profit. maybe the Furies are the part of human nature that wouldn't bow to a natural law theory, even if it believed in it.
I might interpose and follow up a little bit on John's question. One connection, unless I missed it, and maybe you said it, but one connection you might make with the Furies is the attachment to the land and sort of principles of autochthony and, you know, the place. And I wondered if that might be something on, I'm just guessing, but if that might be something on John's mind, the sort of principles of one's own and of the natives, so to speak, that are attached to a place. Seems like that's part of what's going on with the Furies. But maybe you don't have to do anything with that, but that just seemed to me to be another aspect that someone might think about in relation to politics broadly.
Yeah, okay. So that the Furies are local, you're
Yeah,
saying.
so that's the kind of thing.
And the kind of law that triumphs, that makes them second place, is more universal in scope, perhaps.
Yeah.
Interesting.
Yeah, maybe. Okay, so we have another written question from Preston and Sarah. At least that's how they show up here. Are you yourself an adherent to natural law theory? How has your perspective on the question of natural law versus contract theory changed over the course of your career? And what has influenced your thinking on this?
Thank you. I certainly originally was in love with natural law theory, and then came to see, as I say, something beautiful about the way in which natural law theory, sort of working in tandem with a more agreement-related approach to law, could create these new things. But I think if you pressed me on where I finally end up, the place that I go to is to the thinking of a philosopher who was a great influence on Oliver Wendell Holmes Jr. That is Charles Sanders Peirce, an American philosopher. And he believed that there certainly was such a thing as truth. And the way we get there is by a process of conversation. His model was the processes of science. So that if we want to know the truth about a chemical element, we do experiments on it all over the world in all kinds of conditions. We converse with each other about what we find in those experiments. And we may not ever get to a precise truth because we're not sure everybody's in the conversation. Maybe the aliens will have a different view of this chemical element. We may not ever get to truth, but we get closer and closer and closer to an agreement that is functionally the same as truth. Keep experimenting, keep looking to go that last mile, but so we get closer and closer and closer to the truth. And I guess I kind of see it that way, that the more conversation you have, the more members of the community you have, the more sort of reports we get from judges making their analysis, the closer we're going to get to agreement about structures that really work in human society which is kind of the functional equivalent of truth.
Okay, we invite folks from the audience to ask further questions. Martha, I might inject a question I've been thinking about since early in the talk, if you're willing to take another from me. There's a way of hearing your introduction of natural law theory, contract theory as sort of philosophical positions that then flow into legal thought and legal practice. I was wondering if you might think about or talk about what it would look like to turn that around and think about legal thought and practice as kind of generative of philosophical positions or philosophical ideas. I mean, even the connections you were just making with Holmes and Peirce, maybe pragmatism, could be part of that, but also looking at the Oresteia, there are ways of reading that where it's somehow out of the experience of law and courts that you might see categories emerge that then get traction in philosophy. So it's sort of a simplistic and binary way of asking it, but how do you see kind of cause and effect in those two directions?
Yeah, I think it's definitely the case that people who have, I mean, to put it in a sort of cartoonish way, imagining people who have a completely self-interested motive in getting a certain result. One of the things that they will do is develop a rational reason why they should get that result. And once the development of that kind of reasoning begins to occur, then others start to take it really seriously. Wait a minute, maybe there really is some standard outside of that person's interest, even if it arose merely because of interest. Maybe it points to something more abstract and more philosophical. And so, yes, I think that definitely happens. I guess, and the two are always in conversation. If you ask me the chicken or egg question, I think the thing that really moves me is watching very small children have a fully developed sense of justice. I'm just constantly amazed by that. This is justice really doesn't seem like it's learned.
Thank you. Okay, we've got several questions coming in. There was one that was a follow-up, I think, to what you were saying about Peirce and Holmes from David Conway. Actually, can you follow up on the end of that last answer, if you don't mind, and say more about how agreement may be the functional equivalent of truth?
Well, that seems to me true in two ways. The first way, the kind of smaller way, is just that, as it's true in contract law, that when two people have agreed on something, then that's the standard. There it is, right there in writing, and we don't look to justice except in the cases where it shocks the conscience of the court. But that's a minor thing. I think your question is probably addressed to a sort of bigger thing with regard to Peirce and Holmes. In the case of scientific truth, then if, for example, and Peirce uses this a lot, if you're trying to determine the atomic weight of lithium, then what you do is put all the scientists who have done experiments on lithium in conversation, exchanging data, and you're going to come up with a number. It might well be a number that none of them actually got. It's be a number that would be some sort of average of all of the experiments that were done on the atomic weight of lithium. So there's a way in which, is it the truth? Well, it's the agreement that we have from as many scientists on Earth who have done this experiment. And if you open up a textbook, that's the number you'll find. It ends up being the functional equivalent of truth. We don't know that there won't come, and things like Copernicus and Einstein have made us cautious about these things. We don't know that there won't arise an entirely new way of looking, even at something like the atomic weight of lithium, that will cause us to have a different number or go about it in a different way. So we can't say just because we've got this number that seems supported by everybody, at least in its averageness, we can't say that's the truth. But we can say that for any function we're going to do right now, it's the equivalent of truth, holding out the possibility that everything may change. It's trickier in the case of law because, you know, as I mentioned before, there are lots of things in our modern world that the framers of the Constitution really had just no idea about. So lithium can just sit there and people can try to approach it. But society changes and different approaches to society create new kinds of things. So I've never been absolutely sure whether Charles Sanders Peirce would have been confident that the way Oliver Wendell Holmes used his ideas about pragmatism and its effect on the common law, I've never been completely sure that Charles Sanders Peirce would have endorsed that. But anyway, that's the picture as I see it.
Thank you. Okay, we have another question from a Mr. Grant Franks. A leading question, I venture to say here. In Livy, the 12 tables of the law are established, in part at least, as an accommodation with the plebeian citizens of Rome who resented arbitrary rulings by patrician rulers. Two questions. First, in light of this history, is the existence of law intrinsically liberal insofar as they enable social relations that are different from simple imposition of arbitrary power? Second, ought we then to press the instruction committee to expand the reading of Livy in the sophomore year here to include the rest of book 2?
I think maybe as to the first question, I'm inclined to say yes, and I'm inclined to point to, well, let me withdraw that yes. If I were to say yes, I would point to the question that Walter asked just a minute ago, that I was characterizing as, look, people may start out with total self-interest, and they just have wants, and they use force to get them. But as soon as somebody begins to make the step of, I don't just want this, it is just for me to have it, then you're getting into law, and at the same time, you're expanding the way the community is going to work, so that it becomes what you might call intrinsically liberal. You're going to get new social relations, you're going to get new ideas, you're going to get new products, as Holmes puts it, because you've added a new way of thinking into the mix. There's something more than simple force. I think that's right. Now, of course, looking at it that way, the reason I withdrew my yes is that the alternate position is that there has always existed natural law, and there's always existed a standard of justice, and we may grow into it, but that doesn't change the nature of law. And if you want to use liberal and conservative terms, that kind of makes law liberal in the sense that it's always existed and we don't change it and we don't affect it, and all we do is return to it. So it's a complicated question. As for the instruction committee, I would love to read the 12 tables. I think the 12 tables are staggeringly important, but I'm mindful of the fact that one Grant Franks some years ago managed to persuade the instruction committee to get students to read Justinian, and that was deeply unpopular. It was called by one tutor an ordeal of tedium. So the people who are interested in the law may have different standards than people who are not interested in the law.
Very, very balanced, Ms. Franks. Okay, we've got another question here, anonymously submitted. A superb lecture. The resolution of the Furies' claims are essential to the play's outcome. Indeed, its pity and fear, I think. What the resolution addresses is the idea of a seemingly irreconcilable conflict, quite possibly moved by passion, not unlike the Sunni-Shia conflict for centuries. Athena acted not singly as a juror, judge, and legislator to effect this resolution. Could you comment on the messiness and perhaps need of a place or a figure, several of those words were put in quotes, these three meet, as first a lawyer and then a tutor? So I guess the three being juror, judge, and legislator. Could you comment on the messiness and perhaps need of a place or figure where these three meet, answering first as a lawyer and then a tutor?
Yeah, that's another wonderful question. I really appreciate what people are asking. I think the way it occurs to me to think about that is that what's going on in the Oresteia is the cradle of a new product that kind of requires a certain messiness. And you can see it in the, maybe it's a way of characterizing how I've looked at the Constitution and the Declaration of Independence too. That generally speaking, anytime things are going to change radically in any direction, you're probably going to have to appeal to natural law in order to affect that change. Because if all you're looking at is the four corners of a legal document, then nothing new can happen. In order to have a revolution, you have to claim that there's natural law support for what you're doing. You have to step outside of traditions and customs and agreements. And Athena is a figure that maybe does the embodying of the stepping outside while also establishing procedure. That she's a goddess. She has the power. In fact, as part of the persuasion of the Furies, there's a kind of interesting messiness. She offers to the Furies honor and power in exchange for them accepting this result of the case. And they say no, and they mourn. And she offers it again, and they say no, and they mourn. And the third time she offers it, she just lightly refers to the fact that she's a goddess and she could force them. She has that power. And the third time, they say yes. So persuasion doesn't quite do it. Force is there. And the whole resolution is, as you say, messy, and maybe did require a goddess, but a goddess willing to submit to procedures, at least in some respects, in order to make it happen. That's something I'll be meditating on.
I think a subsequent note said that question was coming from Scott Lee, our friend and last week's lecturer. So we have a pause. We don't have any questions queued up, so we'll take a moment or two to see if we have any more questions. And we have one. Have you ever incorporated a theory directly from a philosophical text as an authority for your legal argument in a pleading? In general, what is your opinion of how philosophical works are received by the courts as authorities? Does it surprise you that it is rare that philosophical theories are appealed to in legal arguments and judicial opinions as legal authorities?
Interesting. I think just to record what I have in fact done, I have on many occasions, on thinking about how a case should be argued, thought about what various authors on the program might have said to this case, and thought about thought about philosophical ideas. I have not often, I'm trying to think if ever, actually cited to a philosophical text in a brief. And I think that that's for really very human reasons, that you're trying to talk to a judge. And just as, in seminar, we try not to discuss books that we don't have in common. It's not going to work very well to talk to a judge about a book that he or she hasn't read, and it's not easy to be sure what somebody has read. So I've never actually done that, and that's especially true at the district court level and even the appellate courts level. I think when you're practicing before the Supreme Court, maybe you might be more tempted to do that, because the Supreme Court is almost always dealing with cases for which the precedent is unclear and which could be decided either way. And under those circumstances, you might want to appeal to general principles. But I would be cautious even there. The preferred strategy for the practice of law is to claim and argue that, in fact, the precedent is clearly 100% on your side, and nobody has to look at anything but the obvious precedents in order to find for you. That's the way law is usually actually practiced, I believe. But as I say, I think about philosophical ideas and authors all the time. Maybe it's like the jury having it, being off stage. But in public, I use the language of precedent.
Thank you. Again, we have a lull, so we can take a couple more minutes. I don't know if your mind has circled back around to the negotiation question with any.
Well, it does occur to me that the practice we get for negotiation is around the seminar table. But the question of what text there is, maybe it's because when you're writing a great book, you're, sort of behind your own ideas, and you don't always think about negotiation. But I haven't yet thought of one that might embody it.
I was thinking when you were answering that, somebody might hear in negotiation an emphasis on the psychological, and that just sort of had me thinking about, there's an aspect of law that maybe seems more like logic and dialectic, and then an aspect that's more like rhetoric, perhaps, just to invoke some of those categories. And yeah. I don't know if I don't know if St. John's, if the St. John's connection to law is sort of more on one side or the other.
Well, it's we don't. Tell me if you think I'm wrong about this, but it sometimes seemed to me that we don't pay as much attention to rhetoric as a discipline as the ancient and medieval world did. And I'm not familiar with what texts we would use if we were to decide to do that. But maybe those would be the texts that would answer that question.
Mhm, mhm. Okay, well, I had some thoughts based on that, but let's let others keep getting in here. So we have another question from David Conway. I've really enjoyed this lecture and question period. Thank you. To jump back to Mr. Franks's first question, is there a difference between textualism and originalism?
Oh, geez, there you're really taking me out of my depth. And for one thing, textualism, I'm sort of divided in my mind because I'm also a student of theology, and I've done a lot of biblical studies uh, around some of these categories of how to read. And I associate originalism with the law and textualism with biblical studies. So I'm not quite sure how to swap them into each other's realm. Um, but I think that that's just an expression of ignorance. And if some of the lawyers in the audience could help me, that'd be great.
I'm certainly less of an expert than you. These terms have been in the news a bit lately. I wonder if originalism points more to the original intent and context, and textualism to something like the plain sense of statutes. But certainly there's a connection, it seems, at least in the popular discourse around them. We don't have any other questions coming in right now. Can wait for another moment, but we can also show mercy. temper,
Well, no, it's been really
temper justice with mercy. Those of us here in New Mexico are absorbing a lot of news today, of course, not unique to our state, but some tightening up of things in the coming weeks here, and people might be a bit preoccupied. Well, before I thank you and close, if we don't get more questions, do you have anything else you'd like to say, Ms. Franks, or anything you'd like to amplify on or add?
I don't think so. There sometimes students at St. John's have been interested in legal studies or mock trial groups, and given how many of our students go on to law school, I've been a little sorry that those things have not come to fruition more.
Mm.
So I think I might want to offer that perhaps we should talk about that again.
All right. Well,
Courts are all online now. Everybody argues by Zoom.
I'm glad you said that, and we've got you recorded and on the record there as a volunteer to help. Indeed, for folks, even some of our students who might not realize this, we do indeed send a lot of our graduates into the law and legal practice. So it's exciting to hear your story, because it gives a particular texture to that, which I think for many of us on the faculty, it's not, and alumni, it's not mysterious. There do seem to be some deep connections between the habits of mind and the study at the college that connected organically to that path. Well, we did get another question. Do you mind
Sure.
continuing a bit longer? Okay, we'll take at least one more question. Marzia Desi, if I'm saying that right. Firstly, thanks for your lecture. And secondly, two questions. The parable, The Problem of Our Laws, that's a title. The parable, The Problem of Our Laws. I think in the parable, The Problem of Our Laws, Kafka portrays a society ruled by the laws whose content is unknown. This looks like it might be a long quote. Our laws are unfortunately not widely known. They are the closely guarded secret of the small group of nobles who govern us. We like to believe that these old laws are scrupulously adhered to, but it remains a vexing thing to be governed by laws one does not know. End quote. What are your thoughts on the accessibility of law?
Well, it is an ideal of American law to that all, certainly all formal law, should be publicly accessible. And what with search engines nowadays, it's actually much easier to get a hold of law and to manage, navigate finding the law you need than it, I believe, it has ever been before. There are a couple of places where there are things that eat away a little at that. And there are two kind of qualitatively different kinds. I mean, there's the whole world, for example, of national security, where, FISA warrants are issued without anybody being allowed to know much about them. I like to think it's the ideal to keep those sorts of really explicit secrets to a minimum. But we fight over that, and we'll continue to fight over that. The other sort of broad thing about accessibility of laws is maybe it's related to some of the comments I was thinking about with regard to the social contract, that the US Constitution is broadly accessible, but some of the attitudes of mind and heart that perhaps develop under the Constitution, or that go into certain interpretations of the Constitution, are part of what might be called a larger social contract that nobody knows how to write down or talk about, and that I'm confident are puzzling to newcomers to our country. So, and that difference between laws explicitly written down and laws that native people in the culture might sort of immediately understand, but are puzzling to others, that is sort of reflects some of that notion about what exactly the social contract is. Is the social contract just a stripped down description, like the US Constitution, of exactly how government works? Or is the social contract, as it is in Rousseau, a kind of broad cloud of all of the traditions and customs and understandings that go to define the society, and no one can write those down? My guess is that Kafka was sort of talking about the second as much as the first.
Thank you. And here's the second question from the same questioner. What are your thoughts on the sedimenting nature of the interpretation of those laws as a limiting of freedom, or potentially an expansion of freedom? For example, Kafka notes in The Problem of Our Laws, so here's another quote, "The laws, after all, are so old. Centuries have worked on their interpretation. Even their interpretation has, in a sense, become codified. And while there is surely room still for interpretation, it will be quite limited. Moreover, the nobility has no reason to bend the law against us, if only because the laws were in their favor from the very beginning, the nobility being outside the law. And that is why the laws seem to have been given exclusively into their hands."
Well, I have to read this. This seems like a very interesting work that I have not read. But let me respond to it, just as it occurs to me to do so in this immediate moment. One aspect of what I was trying to describe in my lecture is that the mixture of natural law theory and contract law theory can be fruitful, can be productive, and it allows for the sort of breaking in of the one on the other. So in Brown against Board of Education, for example, the United States Supreme Court decided unanimously that segregation in public schools was contrary to the United States Constitution. In making that decision, the United States had specifically to reject a previous precedent, Plessy against Ferguson, which had, of their own, this was the United States Supreme Court's own case, had held that it was okay to segregate people as long as the two separate accommodations, whether public schools or train cars, were separate but equal. In Brown against Board of Education, the court said, we can no longer believe that you can have things that are separate but equal. If you're going to be separate, you're not going to be equal. And now we know that. Our beliefs have changed. Well, how do the beliefs change? Partly, there was a lot of science in the briefing on Brown against Board of Education, a lot of psychological analysis. But I think the court was pretty candid in saying something like, or that the tenor of the times had changed. Some new thing had entered. It sounds like Kafka lives in a world where new things are not allowed to enter, where their laws are immune from change. American law, as I've tried to describe it, is not immune from change, and there have been some quite extraordinary shifts in how people see the law. But that possibility of change, I think it may come about because the foundation of law is kind of philosophically incoherent.
Thank you, Martha. And I think that might be a fitting note to conclude on.
Yes, but productive, valuable, creative. There, that's a better note.
Okay, that's still a better note. Well, thanks to all who attended this evening. It's been another fruitful occasion and a very good way to connect. And again, I just can't thank you enough, Martha, for sharing your thoughts and experience with us this evening, and for joining us on other occasions through this semester. So thank you so much.
All right. Thank you all. And
good night and good weekend.